And welcome back. I want to take you to this, a story that has gripped the nation and sparked outrage in KwaZulu-Natal. The devastating tragedy involving the 8-year-old Dlamini twins has taken a heartbreaking turn, leaving one child dead and the other fighting for her life. A traumatized Durban father is considering legal action after his 8-year-old son was killed. In a major development, the property management company HOMII Lifestyle Management has reportedly handed over crucial surveillance footage of the incidents to police following public and family pressure. Meanwhile, the Department of Labour has launched a full-scale investigation into the building's compliance with safety regulations. We now bring in legal expert Emmanuel Netshipise to help us unpack this. Emmanuel, thank you so much for your time. Really do appreciate it. The Dlamini family is pursuing a civil claim against the property management company. In simple terms, what is the legal threshold for providing, or at least for proving, negligence in a case like this? And how critical is the Department of Labour's investigation into Occupational Health and Safety Act compliances to the success of that claim?
Thank you very much, sir, for having me. In terms of the law of derelict, the owner of the property has got a legal duty to make sure that the property is fit for use and that the property does not injure or give rise to a hazardous conduct such as the present one. Then for the family of the one who's injured and the deceased to succeed in a claim against the property owner, they must show that the property owner breached that legal duty as a result of negligence by failing to make sure that the property or the lived concerned is fit for use by humans, and that there is a causal link between the loss or damage suffered and the lived and or the property concerned. Those are the threshold. Lastly, is that as a result of the failure by the property owner to make sure that the property is fit for use, they have suffered damages. And prove the damages that they have suffered. Either damages might be the general damages, which is pain and suffering, or loss of money, which is in a form of hospital or medical expenses. And lastly, it can include damages such as shock. Yeah. That is all that they can prove to succeed, sir.
On the one hand, they can pursue a delictual claim, but can they also pursue a criminal claim against the company, given that the negligence has led to a loss of life? And of course, a dereliction of duty can, in many instances, as we know in our jurisprudence, meet a threshold or be tantamount to criminal action. Can criminal charges be pursued in this instance?
If, for example, there can be evidence that the building was declared to be a problem building, which requires certain measures before it can be habited by humans, and the property owner acted against that directive, perhaps from the Etikini municipality, that can give rise to a criminal case. Or if perhaps there was directive issued by the Department of Health not to use the building before certain compliance, then and the building owner acted contrary to those directives, it can give rise to a criminal case. Those are instances wherein the criminal law can come into play.
And what would the sanction for that be?
Normally, in criminal cases, unless if there is a statute which prescribes that contravening this certain conduct, these are the punishment which the court can mete out. The powers to impose a sanction is vested with the court. Then the court will take the severity of the conduct into consideration and the personal circumstances, the justification which the building owners might give, and then decide what is an appropriate sanction to give out.
Yeah, there are other statutory bodies that also need to act on this, and that is to say the CIDB as well as the NABRC, which are statutory bodies that gives license to operate to an organization and a company like this. They too have to act on this. That means that this company may lose its ability to operate and to trade continuously. How important is it that they form a part of the delictual claims?
Normally, those institutions that you have referred to, they are involved before a building is approved for use by humans or whoever. Then if they can conduct their own investigation and conclude perhaps that the owner maybe misrepresented the facts and which gave rise to the approval of the building. Therefore, they might then proceed with investigation to decide whether maybe to issue penalty and take away the licenses of the building owners. That might be the remedy.
Yeah. Let's talk about the types of claims that the family can make. I mean, in this instance, there's one child that has died as a result of this and another child that is fighting for their life. One would presume deeply traumatized by this. And of course, there's pain and suffering on the one hand in a delictual claim. But what are the categories of damages that can be pursued by the family?
Thank you very much, sir. With regard to the one who is injured and is in hospital, the family has got a claim for general damages, that is for pain and suffering. And if, for example, the child concerned is in a private hospital wherein the family will incur hospital expenses, then the family is equally so entitled to claim for hospital expenses. And again, if it can be found that, but for the accident and the injuries that have been sustained by this child, he or she is no longer going to be able to be competitive in an open labor market, then the family is entitled to claim for future loss of income because the child might be regarded as unemployed in the future due to the accident. Then with regard to the one who passed away, they can claim for funeral expenses and for shock as a family.
Yeah. Well, we're going to have to leave it there. Thank you so much for your time. Thank you so much for your insights. I really do appreciate it this afternoon. That is a legal analyst as well as attorney Emmanuel Netshipise.